SJC-13386, Chris Graham and others, v. Hampden County District Attorney.
Okay, Attorney Siegel.
Good morning, Chief Justice Budd, and may it please the court. With one federal investigation concluded in Springfield and another underway in Worcester, this case asks what legal duties arise when, as the special master put it, a law enforcement agency alleges, based on an extensive investigation, that Massachusetts police officers have engaged in a pattern or practice of misconduct. Now, to explain why what has been done so far is insufficient as a matter of law, I want to first start with 4 facts that together demonstrate that people in Hampden County have been and are being prosecuted and imprisoned without receiving all the evidence to which they are entitled. First, the July 2020 DOJ report alleged not only a pattern or practice of misconduct, excessive force by Springfield Narcotics Bureau officers, but also that that excessive force, that misconduct, was likely more widespread than was captured in SPD documents because the police department was systemically incapable of policing and investigating itself. Second, the DA has access to all of the documents that the DOJ reviewed. Not just as a matter of law, because these were officers serving on DA prosecution teams, but also as a matter of fact, because since December 2020, the DA has had a standing written offer from the city to review, quote, all of the materials supplied to the DOJ. Third, despite that access, in response to the DOJ report, the DA reviewed precisely 0 SPD documents from July 2020 until July 2nd, 2021. And since then, it has received and reviewed a total of 712 pages, representing less than 1% of the documents that the DOJ reviewed. Fourth, the DA has conceded in its legal briefs and in its sworn testimony before the special master that the reason that it has accepted that 712 pages, not more, not less, but precisely 712 pages, despite the city's red light warning that this disclosure is not exhaustive, is that the DA has a practice of letting the police decide what evidence is exculpatory and whether the police will turn it over in their discretion. And what the DA does is it simply provides, according to the first assistant, what the city provides. Despite those facts, the DA says that the 712 pages and a rebuttal authored by someone who is himself implicated in 4 of the 16 incidents he addresses, that rebuts the DOJ's allegations. And this is like looking at ice floating in the water and concluding that it's not the tip of an iceberg, while at the very same time refusing to look under the surface of the water.
Counsel, can I ask you about that? Because you're going from the DOJ report to that conclusion, but there's an intervening 4-day evidentiary hearing that we have a 60-something page special master report. Let's talk about the master's report for a minute. A lot of what was alleged to have been this widespread 10 to midnight kind of context out in Springfield, was that really borne out in the special master's report? I'm beginning from your first fundamental premise, that there is this widespread activity by the Hampden County District Attorney's Office of not turning over what is potentially exculpatory evidence. Did the special master agree with you there? And I mean, that's a yes or no. Did she agree with you from that premise, because you asked for a bunch of things downstream based on that?
I can give the best yes or no I can, which is I think as a matter of law, either she didn't address it or she didn't agree with us. I think that as a legal conclusion, maybe not. But I just want to say, Every single fact that I just said is either a subsidiary fact found by the special master or admitted to by the district attorney. Every single one. So what happened in the special master's report is the subsidiary facts actually do support our claims of misconduct. To the extent that the special master didn't conclude that there was misconduct, that appears to have been a legal conclusion at most, that those subsidiary facts didn't carry the day, or that they were best left to this court. We don't really know because we lodged objections and we don't know how the special master would have responded. But let me tell you what I mean about the subsidiary facts. It's in the special master's report that there were no disclosures of SPD documents to the DA until July 2nd, 2021. It's in the special master's report that the city made an offer on December 10th, 2020 to make all the documents available. I would think that the one thing that I mentioned that isn't so far, that isn't expressly in the special master's report is that fourth point I mentioned, which is the DA's policy. But that's from the DA's first assistant's own sworn testimony. And I'm referring especially to pages, volume 3 of our record appendix, pages 199, 372, 392, 395, and 414, where the first assistant said, we just turn over what the city turns over. Now, our view is that that's contrary to binding case law of the Supreme Court and this court, including Kyle's against Whitley. I don't believe the special master addressed that, but to the extent, even for the sake of argument, it would have, if she did, it would have been a legal conclusion.
I'm sorry, Mr. Segal, is the raw data available to you?
I'm sorry, the raw data.
Raw data from Springfield PD.
No, Your Honor.
114,000 pages aren't available to you?
No, Your Honor. And if it were, right, even if it were, as a matter of law, and I think this is something that Justice Kafka wrote in his decision in the Sutton case, which we included as an addendum, even if it were, it would be incumbent as a matter of law on the DA to review those pages, decide was it exculpatory, and make its own assessment of what ought to be disclosed.
I'm just trying to flesh out, in this case, the duty to investigate, which I think this really boils down to. Because disclosure is relatively easy. The principle is easy to state, but in practice, difficult. And when we look at Kodo and where, I think that's really the basis of what you're asking for. We had the situation, is this another Dukin, or is it 6 cases?
Right.
We don't know. So the court said, someone please look at this. And ironically, if you recall, what sprung from Kodo and Ware was an incredibly ineffective report that did nothing. And it wasn't until, you know, it was the further disclosures. The Kodo Ware, the offspring of Kodo and Ware was a feckless investigation. But be that as it may. Just for my own understanding, Your Honor, what I think Your Honor may be referencing is the investigation as to the alleged attorney misconduct. But the Kodo investigation by the Attorney General's office, which wasn't undertaken until this court said, please investigate, was enormously important and changed the scope of the... That was the second step.
Okay. Okay.
There was an intermediary step. But
I just want to make sure we're on the same sheet of music.
No, we have. I'm kind of, we're both familiar with what happened with Farag. and so what, 30,000 defendants where the case is dismissed. So I don't want to belittle that. But anyway, getting back to this. So we have Kodo and Ware saying, is this a Dukin or is this 5 cases? Please look at this. Those are instances, of course, of misconduct by someone on the prosecution team. I'm wondering, where does this case line up as far as what the Hampden County District Attorney's Office has actually done? Does that satisfy their obligations under the duty to investigate, or do they have to, of course, you think they have to do more, but tie this to Kodo and Ware.
Certainly, Your Honor. So under Kodo, first of all, Kodo and Ware write about a constitutionally derived duty to investigate. So although they're under the facts of that situation, a full investigation was warranted according to the court. Even in a situation not involving egregious misconduct, but some misconduct, the duty of inquiry still exists, and the question is what's reasonable under the circumstances.
Right. It's actually, I think that the words are reasonable investigation. Right?
Exactly. And so under the circumstances here, we have a law enforcement agency alleging not just misconduct, but the inability of the agency where that misconduct was housed to police itself. That was borne out also, going back to Justice George, in the special master proceedings, where actually one of the reasons given by the district attorney for not turning over its Nathan Bills file, another fact found by the special master, was that they felt that the SPD made a mess of the investigation process. So given that universe of facts, right, what we think would be required as a matter of law, what would be reasonable under this constitutionally derived duty are four things. Reviewing all the documents. So far it's at 1%, less than 1%. Reviewing the officers involved, the offenses involved, and actually talking to people, which, for example, Deputy Chief Kennedy.
Why is doing it in a global...
Can we get the end of your list before the question?
Go ahead.
Can you just repeat the second one?
Certainly, Your Honor, and I'll just be brief so I can turn to the question. Reviewing all the documents, reviewing the offenses involved, reviewing the officers involved, and talking to witnesses. And by the way, we're not that far apart from the DA in one of the letters that it wrote recently to the City of Springfield, which says, please confirm that you've provided us with all of the exculpatory evidence relating to all of the officers implicated, not just this sample. And that representation, it's never been represented by the city that they've done that. They've represented the opposite. They've said, here is not all of the exculpatory evidence. And this is sort of the opposite of something that this court just found mitigating in the Foster decision.
So I got confused on the list of four. Review all the documents, whatever universe that may be. Review the offenses involved, talk to the witnesses, and
review the officers involved. So it's documents, offenses, officers, talking. And what I mean by offenses are the three that we think are most closely tied to this misconduct, which are
ABPO, et cetera.
Right. Assault and battery on a police officer, resisting arrest, and disorderly. And I'm happy to turn to Justice
I won't
question.
turn over. If Justice Gaziano get his question, are you happy?
Nope, yeah, thank you.
So I'm trying to understand globally. I mean, it's hard to imagine a more careful person than Justice Fabricant. She's had a 5-day hearing. You had an opportunity to present whatever all of the defense counsel out there were aware of. Isn't it better to proceed case by case in a manageable way where the particular officers involved are subject to questioning, particularly post-federal DOJ consent decree procedures which are in place? So why should we basically undertake some gigantic undertaking when we can do this case by case in a more particular and focused way?
So a few responses to that. One is that I want to be clear about the limited nature of what the proceedings were before Justice Fabricant, the Special Master Fabricant. The facts going in, and including the four facts I said at the outset, were largely undisputed. And what this was supposed to be was a narrow opportunity for them to test some of our evidence. That's why the examinations of the defense attorneys didn't start with direct testimony. They started with cross-examination by the DA. So the evidence...
You weren't able to put in anything else before Justice Fabricant?
I don't know about able, Your Honor, but it was our understanding that the record largely existed, and this was an opportunity for them to test our evidence. The second thing, but to your point about why can't this go case by case?
I just want to make sure of that. So Justice Fabricant undertakes this proceeding, including, defense counsel presenting their own war stories, right? So I take it there was some ability to present whatever you were worried about there, because we keep coming back to the same two incidents. The bar fight and the Palmer fight are the two sort of most solid pieces of evidence here.
I think there's more than that, Your Honor, and let me get to that. It's not that we were prevented. My point is that the record is broader than just the testimony. The record is all the stuff that we put in.
The record is the world. I mean,
right. So
in your brief, I think you're talking about going back to 2013, which is 10 years. Basically everything the Springfield Police Department did during that time.
There could be, I mean, an investigation might reasonably be less than that, but it would have to do at least some of the things that I mentioned before. I mean, even reviewing the documents. What Your Honor dealt with in the Sutton case was a larger universe of documents, and in a DA coming to you and saying, I see that my time is past.
That's okay, go ahead.
And a DA coming to you and saying, we would like to just rely on what this other entity concluded, and Your Honor said, you have to look at the document. So that we haven't even, we're far away from review going back 13 years. But on the point of why can't we do this case by case, it's the DA's position, which they repeated not just in the sworn testimony, but 2 days ago in this court, which is that when they ask for documents from the police get to decide how much to turn over. And what they said in response to Justice Gaziano's question 2 days ago was, if they don't give us the exculpatory evidence, we just proceed with the case because we think it's in the public interest to do so. And my ears perk up a little bit when I hear prosecutors say that they take Brady as a suggestion. So that's one thing. But I'll tell you another, just some examples. The reason why we have focused on the Nathan Bills and Wilbraham police report is we don't know what we don't know. We know that they have a policy of withholding evidence that they deem to be misconduct when they can't decide which officer did it. That's the policy that led to the withholding of the Nathan Bills. We are learning all the time about more evidence. Right now, there is litigation of which we can submit a 16L letter and the court can take judicial notice. There's litigation between Officer Bigda, and the city of Springfield. The city of Springfield just counterclaimed, and it's counterclaimed, it says, Bigda actually engaged in 14 instances of physical contact.
But here's a good example. Bigda has been identified. Any case involving Bigda, it's out in the open.
And it's been dropped.
No, Your Honor. They continued to use Bigda as a witness until he decided to stop coming to court because he'd been indicted.
Right, and then those cases were dropped.
Right. So all along, when he was...
So I guess I'm wondering, back to Justice Kafker's question, is why not proceed case by case? You were referencing the case that we had Monday. It was an individual case. It seems to, easily bring up the issues that you are concerned with here. Why do we have to have, as we did with Farrak, a global remedy here when, in fact, we can see that case by case this will come up?
I just want to say, just to finish, if I could, just finish the thought about Bigda. Those cases about him were not turned over when he was getting people prosecuted and imprisoned. And the city's counterclaim also says that there are 3 adverse credibility determinations involving him, one that also involves Kent, also not turned over. These are policies.
To the court, and you can submit a 16L letter about updating us on Bigda. I'm concerned about this court stepping in and stepping over its Article 30 responsibilities. Why do we have to proceed in the manner that you're suggesting we do proceed? Is it because the DOJ has reviewed 100,000 documents and concluded, without identifying anybody, that there is rampant misconduct in a bureau that no longer exists?
So
is that what the
that's the
argument
reason
is?
to do that supplies the legal reason to do more. And the reason I mentioned that the instance, Your Honor, is not because I was sidestepping your question. It is my answer to your question that in cases these disclosures don't get made. This review doesn't get made on a case-by-case basis, absent guidance from this court. What we are actually asking for in this case is much less than what was sought in CPCS versus AG or Bridgman or anything else. We're saying, at the very least, someone has to review these documents, look into these incidents. On the case of the 2 kids or the kid and the adult riding the bike, they continued to prosecute those people without even checking to see whether the DOJ was right. without even talking to anyone. So we want some guidance. You have to review the documents. as you
Okay,
said.
so why can't we do guidance by rulemaking, right? There's a new Rule 14 that's out there. Justice Fabricant seemed to think that that was a good way. You tell me why. Why do we need a fiat from this court in this case?
So there are two reasons, Your Honor. One is that the Rule 14 addresses only one of the pieces, which is when the police intentionally withhold exculpatory evidence. And there are other policies here, like allowing the police to decide what to disclose, which is how we got 712 pages, withholding evidence when there's any question of which officer did the wrongdoing, withholding adverse credibility determinations, on which this court could give guidance and which Rule 14 won't. But on the specific Rule 14 issue, the problem with the draft of Rule 14 that is in circulation is that it would apply the rule for non-prosecution team members. Right now, Rule 14 says if it's a prosecution team member, the DA is responsible as a matter of law for getting it. If the DA comes to learn of evidence that is not in the possession or custody or control of the prosecution team, then I think it's 14A1E says that the DA is supposed to provide notice. And what we've heard in this case and what the special master said was that would also be a good rule for people who are on the prosecution team. And the whole point of Rule 14 as it's presently constructed is that no, that's not the rule for when someone is on the prosecution team.
That's a awareness issue though, isn't it?
Right, so
basically if we, and I know you want us to revisit awareness, but
oh, I misheard your. I don't think it's a awareness issue.
Oh, because I thought it was. If it's not in the custody control, it's held by IA, correct?
I think what Rule 14A1E means is if it could be in the internal affairs, but it could be just a witness who's a stranger to the Commonwealth. It's a rule for witnesses who possess exculpatory evidence that the Commonwealth learns about, over which the Commonwealth has no possession, custody, or control. And that is not an appropriate rule, whereas here you have an entity, the police department, saying, although we are subject to your possession, custody, or control.
I think you're mixing apples and oranges. We have, everybody we're talking about is a member of the prosecution team. We've said that, right? All these witnesses are members of the prosecution team.
Right.
Right.
And what I'm saying, well, no, what I'm saying is that what I understand the present draft of Rule 14, the amendment to say, is that it would say, even for someone who's who's a member of the team, it would be sufficient for the police to provide notice.
And I don't want to...
and for the DA to provide notice.
And I don't want to waste time talking about what a
but,
rule that hasn't been passed
But
says.
my point is just, this will not get resolved, and it hasn't been in 3 years, get resolved on a case-by-case basis if the DA is under...
but didn't the litigation actually, to your credit, and people that brought the litigation, you started at a certain point. You've had litigation in front of Justice Wendlandt for a long time, and you've gotten a lot of what you were looking for. So the fact that you brought the litigation has raised this issue, and you've gotten, at least you don't think the satisfactory, but you've gotten a lot more than you had when you started, correct?
We have gotten 712 pages, and we're grateful that we have that. I would say that that the reason I mentioned the Bigda case is that we are still worried when we have to read in the news or read in a latest filing that there are police officers about whom there are multiple acts of misconduct, including one where he's alleged to have broken a door and broken someone's jaw, and 3 adverse credibility determinations, including one by the author of this rebuttal in this case, that we didn't know about. And that is the problem. Without adequate instructions, without clear instructions to review documents, to look into these events, and to end these practices of withholding things just because the police don't want to turn them over, without those instructions, it will be impossible for case-by-case resolution.
And a lot of this guidance will come in the case that we heard on Monday, as far as adverse credibility findings and the ability to ferret out this stuff from police, correct?
I would say the problem we're going to run into there, and the problem that defense attorneys have run into, is that it's not ripe until it becomes moot. People don't know to ask about the adverse credibility determinations until they learn about them, and once they learn about them, they're told, well, you can't litigate this anymore.
Right. I mean, I think if we're definitive as to what the obligation is, and if you look at the discipline case that came out a few weeks ago, I think prosecutors are rightly, or should be rightly concerned about their constitutional obligations.
Well, I would hope so, but what the record before you here, including the record consistent with the special master's findings, is that contrary to receiving a representation that all the evidence has been turned over, they have received the opposite representation, which is that the disclosures, the 712 pages, though it's a good start, are by no means exhaustive. That's the opposite.
Is the 114,000 exhaustive?
I don't know, Your Honor, because I haven't seen it, and no one has reviewed it.
Well, you know that it's not, because the DOJ suggested that there's more there, and they only got the 114.
Right, and so what we think is reviewing those documents, which is the Sutton decision, would be the bare minimum. It would also have been nice if someone had actually looked into any of the allegations of misconduct, and we think not just nice, but constitutionally required.
Can I ask one more question?
Can I ask one?
Yeah. Well, we're 10 minutes over. Yeah.
All right, you go first and then I'll.
You keep bringing up Sutton, but isn't there a difference between Farrak and the cases where we're dealing with the drug analysts, which are, if they're fabricating the drug certificates, you know, it's direct. Here, you're drawing credibility conclusions based on how, you know, whether they're using undue force. It's different, right? It's much more complicated. It may not be admissible. It's not like the drug certificate cases, right?
I would agree that that it's not on the same exact facts, but it doesn't that's not a fact that cuts against our argument. And the reason,
well, it does in terms of a global remedy, doesn't it? Because the reason we have to dismiss 30,000 cases or whatever, we've got concerns that the certificates are just lies. Right.
Actually, I don't think that was the concern. So first of all, today, I'm not here to ask you to overturn 30,000 convictions. I haven't done that in a few years. And so what I'm saying is...
We can predict the future.
No, I mean, I actually think that what this case has been about is please take a look. Please. And the issue is no one was alleging that Dukin was trying to falsify, to convict innocent people. No one was alleging that Farrak was either. What's going on here is the real possibility of people being convicted of these three offenses where there was never a crime by someone other than the person wearing the badge. It's not just credibility in an abstract sense. It's credibility that can lead directly to the conviction and imprisonment of innocent people.
I was just going to ask, I guess it's sort of similar to what Justice Kafker just asked, but aren't you conflating doing something about policeman misconduct writ large and worrying about specific defendants in their specific cases and making sure they have what they need to defend themselves?
I know that whenever a judge asks me if I'm conflating something, I'm not supposed to say no. So I'm going to say no, but I think here's why I think I'm not. The problem for the individual defendants is that they're going to get just a little piece of the overall misconduct, and they won't be able to show in a particular case, oh, I have a need for you to investigate Officer so-and-so who allegedly hit someone off a motorbike, because the trial judge is likely to say, what has that got to do with you? But as a whole, CPCS, the lawyers of Hampden County Lawyers for Justice, have a need for that. And because the evidence that would be uncovered, just as it was in the Cotto investigation, or could be uncovered, would be applicable to potentially thousands of cases. Would it lead to someone asking for all of them to be overturned? Not necessarily, Your Honor, but it would allow them to have fair trials. And right now, what we're being told is the trials that are going forward based on evidence that the city itself says is not exhaustive.
So, Mr. Siegel, you represent someone in Springfield District Court. They're charged with, I guess, the big three, as they call it, the defense bar calls it, ABPO, resisting arrest, or whatever the other charge was, disorderly. And it's Officer Smith. As a competent defense attorney, you say, I want to see any records of Officer Smith in any misconduct, whether he has any physical altercations, etc. Why can't you do that?
I think that attorneys have been doing that, and what they didn't know that they weren't getting until this case is they were not going to get any evidence of an adverse credibility determination by a judge against Officer Smith.
We'll talk about that with Ms.
Right.
Mobley, but
Right. And if Officer Smith was involved, let's say, in, I don't know, the incident in Palmer, right, or something comparable, they're going to get a sampler of the evidence. And what they won't know when they get that sampler is that it's a sampler, because we didn't know about this policy until this case of just turning over what the police provide. And they might stop there. So the problem for...
So if we give you guidance in this case, in the McFarland case, that talks about adverse credibility findings in civil lawsuits, etc., doesn't that answer the question?
I can't speak, I'm not counsel on McFarland, so I'm going to be careful about that. But I will say, with respect to this case, there are really 3 pieces of guidance on the disclosure piece that this court could give based on this record without contradicting anything the special master said. One is the DA has said in testimony that they just simply provide what the police provide. It would be helpful to remind the DA that that is unlawful under Kiles versus Whitley and other things. The DA has this policy about adverse credibility determinations. That's inappropriate. Even the special master agreed with us, I think, on that. The third thing would be, despite admonitions from the courts that doubt should be resolved in favor of disclosure, the DA has a policy of resolving doubt in favor of withholding when the doubt is which officers committed misconduct that is the existence of which is not in dispute. Those 3 things on the disclosure piece would be very helpful. On the investigation piece, even if the court is not going to say, do a CODO convene a grand jury, right? There are many things short of that are not being done, including just reviewing the incidents alleged by the DOJ and reviewing the paper.
Is that an Article 30 issue if we say convene a grand jury?
Well, no, I'm just saying, even if what your court does not have in mind, right? On the Article 30, in CODA, the court side said just, we would like to know.
We'd like to know. We didn't say how to investigate.
But
we just said it'd be nice if we knew if this was a Dukin case or not.
And what I want to be clear about, though, is that we are saying that these are constitutionally required. Can
I just press you on that just for a second? So you say do what, you've got the King report, right, at this point? Do you have the
Kent.
Excuse me, the Kent report? You have that report? Because remember, the DOJ doesn't identify who these people are, right? It's this classic federal, they produce the result they want, which is the consent decree, but they're not identifying these incidents that they're describing by name. But you've got the closest, you have the Kent report, right?
Well, the Kent report is more accurately described as a cover-up. I mean, just to be clear, I mean, I just don't think that it is.
But that's the attempt to identify what the DOJ was talking about.
Right,
correct?
and we've had, let me just be clear, that identification process was concluded by October 2020, and but for this lawsuit, I'm not sure we would ever have known about it. Yes, the Kent report, we now have the Kent report. The problem is that it is not an attempt to get to the bottom of what the DOJ allege, is an attempt to disprove it. And we think that document...
But that may be its object. Doesn't it, though, go through the DOJ report and identify the incidents which are otherwise not identified, other than Nathan Bills and
it does identify 16
So using
of them.
that information, regardless of whether or not it's a rebuttal or cover-up or however you want to characterize it, now you know what the DOJ is alleging.
And that is true. But if that was up to the defense, then there would never have been a CODO report, because once Attorney Luke Ryan found the mental health worksheets, the defense bar could have figured it all out. And the problem is the defense bar can't figure it all out. We don't have subpoena power. We can't convene grand juries. We can't immunize witnesses. And so there's not going to be a way to get to the bottom of what happened, absent some undertaking on behalf of the Commonwealth to understand whether these 16 incidents identified by Kent are whether it's true what the DOJ alleged, and if it's true, whether there's more. We just can't do it ourselves.
So we're going to find out what the DA's office is willing to do.
Thank you. Thank you, Your Honor.
Thank you. Attorney Mulvey.
If it please the court, Elizabeth Mulvey for the District Attorney of Hampden County. I'd like for just a moment to go back to the question that's actually before the court, which is, has the petitioner or have the petitioners proved that there's a crisis in Hampden County such that this court should issue extraordinary relief under 211 and 231A? That's what brought us here. That's what sent us to the special master, and she found unequivocally that there is not. And that should be the end of this petition. But
how many officers are identified by the DOJ report, or now have been identified as involved in the misconduct?
I think approximately 30.
30, and they were mostly in the Narcotics Bureau,
Yes.
which is now disbanded? And you don't think that that's a problem of large proportion?
Well, I think that's a huge question, and let me start after it. First of all, the issue is, does there need to be some sort of investigation? And I'm going to pass the question because I think there is an Article 30 issue, and I think it's more than that. With all respect, it's the district attorney's determination how he uses his resources. He doesn't think it's a good use of resources to go back to 2013 to investigate something that the federal government spent 2.5 years and God knows how many millions of dollars doing. And whatever he did, it will not be enough, because all of the amicus briefs, the petitioners themselves, have said that the district attorney shouldn't be doing this. He's too close, he's biased, he's part of the misconduct. But he's the one that's the party in this case. The Attorney General, as they said to Justice Fabricant, is aware of this case and has no interest in participating. And more important, on sort of a moral basis, there is no evidence that exculpatory information is not being disclosed.
I think Mr. Siegel's point is we don't really, even if we do this on an individualized basis, the way the documents are being produced, the way the decisions are being made, we don't know sort of the standards they're applying. And that, I think that's what he's saying, that how can we even do it in an individual case if the DA's office is making a decision to turn it over or not based on, sort of its own judgment calls.
That's what DA's offices do in every county in the Commonwealth. They get evidence and they decide whether to turn it.
But he's saying based on the past, we weren't given things that we clearly should have been.
Well, first of all,
Big duh.
That's not true.
Okay,
the way
so
Bigton came to light was that the CDs of that interrogation were produced to 3 defense counsel who did nothing. A line ADA in the district court on a Saturday in July was looking at those CDs in preparation for trial and said, oh my God, and called the supervisor. That's how Bigton came to light. First, they produced it, and second, they recognized it when defense counsel.
So when we go through all of Justice Fabricant's findings and other things.
I'm sorry, I missed the.
So when we're going through Justice Fabricant's findings, basically, the Springfield DA's office has been doing just fine in what they're turning over. There's no cause for concern. Everything's basically in good shape after the DOJ report. Is that what you're telling us? So we shouldn't even make any clarifications in the law here about.
Well, that's a different question, and
Okay.
I'd love to talk about that too. But to the first part of the question, they were given extraordinary latitude, not just by Justice Fabricant, but they presented affidavits with their original petition,
No,
which
my
turned.
question's a little different. When we're looking at the past practices of what's been turned over here, there's no cause for concern that the police department was producing the stuff that the DA's asked for and it was being turned over?
There's no evidence to the contrary.
Can I ask you about 2 aspects of the discovery practices I find concerning.
Sure.
The first is the determination by the DA's office that when they have an incident and the identity of the police officer is in question, well, it's not exculpatory because who knows who did it. And the second is when there's an adverse credibility finding like Judge Sweeney made, and the DA says, well, that's explainable, so we're just not going to tell you about that. That's incredibly risky, in my opinion. Can you address those two practices?
I'd love to, actually. As to the first one, that information was disclosed to the defendant involved. The issue is when you get to collateral cases under matter of a grand jury, how do you know as to which officer to disclose it if nobody's identified? This was a Wilbraham police report that said a Springfield police officer kicked the kid. The federal government indicted 2 people and managed to prove neither one did it. The kid never reported it, so there was no attempt to figure it out on the defense side. But the issue then is there were several police officers there. As to whom is that exculpatory in a collateral case, I think is the issue there. It's not that they didn't turn it over in the underlying case. It's that, do you turn it over in every case in which every one of those officers was involved? If the answer is yes, tell them and they'll do it. But I don't think there's anything in any case.
Well, I know what my answer would be if I was a supervisor in that DA's office. It would have been to turn it over, but that was a long time ago. So.
It was before matter of a grand jury. It involved a juvenile. I mean, it's not quite clean and tidy.
Right. Address number 2, please.
Let me take number 2.
Yep.
I think that on an appropriate case, that would be good for the court to address, but it's a really messy issue. As Your Honor noted on Monday, sometimes judges are nice and they say, I don't believe the officer. Sometimes, given that it's the Commonwealth's burden of proof, it's truly a toss-up. And the judge says, I find the Commonwealth hasn't met the burden of proof. Does that mean the judge believes the officer lied? I think going back to matter of grand jury.
But when I read Judge Sweeney's decision, it wasn't, well, I don't want to say she wasn't nice, but when I say she was direct.
She was, but she also didn't have the whole picture.
But whose call should that be?
Well, as of matter of a grand jury, the language is if the prosecutor determines that the officer had lied. And that's important in a couple of the cases that they've cited here because the prosecutor had information and witnesses that weren't at the dangerousness hearing, weren't at the motion to suppress because nobody knew it was an issue until it blew up in these poor little DA's faces. But I'd like to point to what I think is the most egregious example, which is a finding way back in 2007 or 2008 as to a client represented by David Hoos, who's president or was president of Hampden County Lawyers for Justice. He admitted that he has never tried to use it. He never gave it to anybody in his office. He never gave it to the Hampden County Lawyers for Justice. He never suggested to his friend, the DA, that he should be disseminating it. And 4 DAs before this one didn't see fit to disseminate it. Now, could there be room for a real narrow rule that if the judge specifically makes the finding, yeah, sure. If you tell them to do that, they'll do it. But if you look at the record in this case, they managed to find exactly 3 examples, and 2 of them were mushy. So I'm not convinced that that's, a huge problem. I think most of them are soft. Most of them.
Attorney Mulvey, I'm a little surprised that the DA's position is that there's nothing to see here and there's nothing that needs to be done. It seems to me that it might behoove the office to say, what should we be doing in the interests of justice? Has there been any, what are they planning to do?
They believe that they are turning over exculpatory evidence. And the record shows that they have.
So nothing needs to change?
Well, they're apparently doing a pretty good job. As I said to somebody, they'd be happy to put their record up against Suffolk County.
But was
Yeah.
that was, but what about the Brady Committee with Justice Cordy? Wasn't that a reform that's been imposed?
Yeah, they have a whole new policy that they didn't have before that was reviewed by ex-Justice Cordy, and they're following it. Frankly, they're scared to death, even before Foster and Kaczmarek. You've got these little DAs with piles of cases, and they're terrified. And, you know, maybe they should be, but they are. The message
So
is
that
clear.
screams for clear guidance from the court as to what their responsibilities are, so that the prosecutors, little as they are, aren't scared.
Yeah, and could I take a swing at the softball from Monday, which is just give it to them, what difference does it make? Because I think that's really the issue, is why not just say give them everything and let's see what happens. I think off the top of my head, I can think of 6 reasons. First, as the record in this case shows, and it's the best record anybody's ever going to have on a DA's disclosure practices, shows that they're doing a pretty good job. Are they perfect? Probably not. Are they doing okay? They're doing pretty well. Second, we have the Rule 14 committee, which spent 4 or 5 years doing yeoman's work. I would suggest that maybe it would be a good idea to get that implemented and see how that works before we go creating collateral issues. 3 is that there's really a slippery slope here where we're looking to make the prosecution not just responsible to identify existing evidence, but to become the defense investigator. And I recognize it's a slippery slope and it's a line, but it's never been the law that they have to go investigate to develop exculpatory evidence as opposed to identify existing exculpatory evidence. Frankly, if you're going to make them a defense investigator, it would make more sense to send them after stuff like Bohannon evidence or adjutant evidence or mental health records of a complainant that might be relevant and admissible. 4th, it's a huge administrative nightmare, and that wouldn't excuse it if there were a constitutional need and if this evidence were useful. But what you have, and Mr. Shepard-Brick did a pretty good job, but this is not a simple matter to go asking all these officers all these questions, because unlike a conviction is static. It's happened, it goes in the Brady database, it gets disclosed.
I'm a little confused, though, because I am focused on what you call the little DA in the individual case and why they're so frightened. Because it seems like everyone has an interest in clarifying exactly what that is.
Because McFarland said, we're going to take your head off if you don't do
Right.
formal, informal, internal, external, civil, criminal.
And Justice Gaziano asked you about 2 of them. Is there anywhere else that the DA wants us to clarify that? Because I do have problems with this global, gigantic investigation, but I don't, in the individual case, I want to be confident that we are providing clear enough guidance so that, you know, we're not dealing with, you know, claims of cover-up and everything else, because I don't quite have the same level of confidence that everything is completely hunky-dory out there that you do.
Well, they were given the opportunity. I mean, if they show us something, we'll be happy to address it.
Justice Fabricant, it's pretty nuanced. It's not a complete comfort level, is it? But anyway, so there's nothing more for that, what you call the little DA, that we should be doing to clarify what they should be turning over.
I think that there's this sort of, and it's amorphous at this stage, this sort of, is there a duty of inquiry? What do you have to ask your prosecution team witnesses? But I think it's
in the context of the police are not fully, the police are an independent entity. It's not like the federal government.
Yep.
And they're making their own judgment calls, which are exposing your clients sometimes. So again, it's all perfect
Sometimes they don't even know.
Well, but again, what should we be, what should, is there anything
Well,
more we should
with
be doing
respect
to
to the-
empowering the DA's office in relation to the police department? Or is, again, this, you're comfortable with the way everything is?
No, with respect to that specific issue, I think the court ought to say this is not the prosecutor's responsibility.
But there's no hear no evil, see no evil exception of Brady, right? You have a duty to inquire, and if, you know, there are giglio letters, there are procedures you can implement where the DAs can be satisfied or at least fulfill their obligation of reasonable inquiry to find out if something's amiss in this misconduct with a police witness.
All right, reasonable. Can I pick up on reasonable? I think I looked, there are 160,000 district court cases in the Commonwealth every year, criminal, with multiple officers. And right now, as
My copy of the Constitution doesn't distinguish between the little DA and the big
no,
DA.
just, can I walk that down the road?
Yeah.
It would be one thing if this were COTO evidence, if it went to an element of the crime. But we are talking about evidence that today, in September of 2023, is pretty much no way, no how admissible. It, at best, there's that little teeny, what do they call those arrow windows, balustrade or something like that, left in that.
Well, if the case is, you know, two officers say that I had a gun in the front seat of my car, and the two witnesses say, no, he didn't, and the two officers were subject to the DOJ report, wouldn't that be information that the DA should be looking for, consistent with their Brady obligations? Because at the end of the day, it is a credibility call.
Well, except I think we've got the cart screaming down the road while the horse is still eating hay in the barn. Under what section of the evidence law does that come in? Now, if this court wants to go to 608B.
I've got to go back to the conflation thing with Attorney Siegel. Now, aren't you conflating what your duty is to investigate and disclose with what's ultimately admissible? Admissibility is not the test.
That's the hardest question in the case, because 100% admissibility is not the test. But on the other hand, we have reasonable inquiry. Is it reasonable to make people do all these thousands of inquiries if there's this much chance that it's admissible? And I think that's a really, really hard question.
I guess that's a question that you answer, because somebody could be going to jail if the inquiry isn't made, right?
Well, but is it, somebody could be, but there's no evidence that they are.
Right, so I mean, the basic,
What's reasonable?
we have in re grand jury, right?
Yeah.
At this point, we don't have 608B, we have in re grand jury, which stands for when these bad act instances of misconduct would be admissible. Taking aside the CODO where Dukin, which is an easy call, frankly, because of the exculpatory.
Yeah.
So we do have that, the ability of a defense attorney to marshal that evidence to get in re grand jury impeachment essentially, correct?
Yeah.
So then the question becomes, what labor has to be undertaken by a DA's office to gather that evidence to give to a defense attorney? That's really the issue, right?
And I think that's where the reasonableness, that's where the rubber meets the road, and I don't profess to have the answer, and there are different answers. There's, you know, when you have a hammer, everything looks like a nail, so I'm going to say reasonably calculated to lead to the discovery of admissible evidence. There's the Garrett case that was actually cited, I think, in CPCS's amicus brief in the McFarland case, where New York says you're only a member of the prosecution team as to the investigation in the case, but not as to unrelated issues.
Isn't the answer in looking to what the feds have done in Giglio as far as what the disclosures have to be?
Well, there are two answers to that, I think. First, the feds have 608B, and we don't. So
we have in re grand jury, which may be broader than 608B.
Well, yes.
So moving past that, second.
But matter of grand jury, it leaves this theoretical, and it says, look at the age, look at the simplicity, look at the blah, 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 blah.
Let's get past that, right?
I'm not aware of a case in which that type of evidence has been admitted, before or after matter of a grand jury. So I think that tells us that maybe there's nothing that's all that compelling out there. We're all drawing inferences. But if that were such a screaming problem, don't you think somebody would have brought this case to the court?
Well, that's not necessarily true, because if you did have that, I agree with Justice Gaziano, that grand jury might be a little bit more expensive than 608B, and you might have had an acquittal as a result of that, which is why you don't know about it, because the defendant was found not guilty. So
then the system worked.
Well, perhaps, but you're saying that inures to your benefit when it actually might inure to the other side. But I'd like to go back to something you said a little while ago. The problem that I have with what you're saying about the reasonableness is, I still have my muscle memory of being a BMC judge, where every time you come into a session, there's someone on the prosecution team telling me how busy they are. They're telling me how many cases they have. They're telling me that they just got the case that morning from the other DA that moved up to Superior Court or went to another division. They're telling me that they don't have the discovery because the detective's not here to give them the packet of materials. So when you start talking about reasonableness, it really starts to get something that gives me a little PTSD about whether or not somebody is falling in between the cracks and not getting what they're supposed to, because no one is passing this hot potato and no one's taking the time to ask, did we ask? Did we ask them for the grand jury material? Did we ask them if they're litigants in a civil suit? Did we ask them if they have disciplinary? No one's asking. And so when does it become the fact that this is what it is in district court practice, in community court practice? You're going to have a lot of cases, you're going to be very busy, and the Constitution just doesn't care.
I don't think that's quite accurate. Yes, they're busy, but they are asking.
Asking what?
Well, right now, Hampden's asking the permutations of the six, the three either-ors. And they're getting, they're getting nothing.
But they're asking, so this case
they're
serves some purpose.
And they're gonna, if you tell them they have to, they're gonna do it, but.
And you think that's unreasonable in light of the potential inadmissibility of the evidence anyway?
I think it's more than potential inadmissibility. This court keeps telling us, Sousa last month, that we don't like propensity evidence. And in essence, what we're talking about is propensity evidence. It's not 609 impeachment. It's not 613A impeachment. It's really, this officer's a habitual liar or a habitual bad guy.
I'm going to push back on it. It's not propensity evidence. And if you're looking to some of the reasons why you might offer it, that this officer has a pattern of doing this in every case. When you have somebody that disagrees with the command, all of a sudden they're charged with the big three. Now you get the ABPO, now you get the disorderly, now you get the resisting arrest. And if you could show that there's a pattern to that, that's not propensity.
That's actually, I think, I would argue that's propensity used under adjutant. And as I said before, if you're going to make them ask questions, that wouldn't be a bad question to have them asking, because we know how that's admissible.
So then we won't let the DAs put in uncharged misconduct because the defense attorneys say that's propensity all the time.
Yeah.
Okay. Let me ask you, and I want to give you the opportunity to finish your answer that I cut you off on. I said, why not a Giglio list or Giglio inquiry? You said 608B, then we got backtracked about in reg grand jury, and then you were going to say something else. Do you remember what the something else was? You could rewind. I don't know.
It seemed important.
Yeah.
I'm sure it was very important. It may have had to do, it certainly had to do with 608B. It may have had to do with the structure and the numbers. Okay. I don't know how many cases the U.S. Attorney's Office has, but every single district court prosecutor in this Commonwealth has multiple times more than that. And again, if it were COTO evidence, if it went to an element of the crime, if it were the gun license, I get it, 100%. I'm not.
But it's just officer credibility, so
well, it's
we're too busy.
Just. I think it would be easier, and when the question was asked, what guidance can you give? The best guidance would be the end. How are we going to use this stuff?
That seems like, why would we do that as a global basis? I mean...
No, I think it ought to be done on a case-by-case, and that's what I said in my brief, because...
So to that suggestion, opposing counsel said something like, it's not ripe until it's moot, and that's why we need this global remedy. What's your response?
Global remedies are extraordinary. Even in Cotto, this court turned backwards somersaults to avoid a global remedy and finally felt
But if it's not ripe until it's moot, that I think the point was we need this case, a guidance in this case, decision in this case, in order to get to the individual cases.
The record belies that, because both in front of Judge Fabricant, and I actually wanted to bring this up because the reply brief accuses the DA of making false statements. In fact, if you read...
Okay, so let's just, I know the record really well, and I'm sure the other justices do. Can I just ask the question?
Sure.
So, well, the record shows what the record shows. Let's assume the record suggests that the Springfield Police Department had a problem with false arrests and Fourth Amendment violations and covering up for each other. Let's just assume that that's what the record will show. Why is this case not the right vehicle for giving the guidance that petitioners want?
Because it's old and unproven. If the Kent report does nothing else, it at least raises some questions about the DOJ. You know, the DOJ, I would argue, made interpretations rather than inferences and called things fist strikes. They misidentified the number of officers at the scene. And we're talking about some things that happened a long, long time ago. I don't defend them. Nobody's defending what these officers did. But the question is, as to defendants in cases now, is that evidence exculpatory? And everybody knows what everybody knows. There's no secrets in Springfield. And going to the reply brief, I think what the...
That sounds overstated, I would think.
I'm sorry?
That sounds overstated, that everyone knows everything that everyone knows in Springfield. I mean, it's...
There aren't a lot of secrets in Springfield, Massachusetts, but what the record shows is that...
But I don't understand that. If there aren't a lot of secrets, why not just... And everybody knows what everybody knows, then why not just give it to every defendant in every case where the police officer, everybody knows, is a liar?
Because
right?
Most of those police officers aren't there anymore.
Okay.
I mean, that's why there aren't motions for sanctions. But what the record does show, and why I think a global remedy isn't necessary, is that it shows that the system is working. Every day in the trial courts in Hampden County, district court judges and superior court judges are taking these motions and they're ruling on them. And that's what the system is supposed to do. If they feel like they're being deprived of something, they can go ask for it. And sometimes the judge says yes, sometimes the judge says no. That's the way the cookie crumbles. But they're asking for far more than they're getting. They're asking, for example, that the DA explain to them why evidence is exculpatory. And I think that's really such, going back to this big question of what's exculpatory. As a trial lawyer, I'm terrified at the idea of relying on my opponent to figure out what's exculpatory. I mean, part of the art...
that would give you pause when you figure out what's an adverse credibility finding. That should terrify you as well, right?
It does, because it's... I mean, I think we cited a bunch of them in our original response to the petition. I mean, those come in all flavors. Right. And the eye's in the beholder, and sometimes it was a different issue. It's not clean. And maybe there should be a rule, but maybe we should see a case to make the rule. That's why it's so difficult to answer these questions. Going back to Cotto, one of the best pieces of lawyering I ever saw was Luke Ryan figuring out that from a Saturday football game, you could figure out what year that was. That doesn't, on its face, look like evidence favorable to the defendant. I'm not talking about the mental health worksheets and stuff like that. I'm talking about, without knowing the defense, you know, one of the arts of trial practice is taking an innocuous-looking fact and using it to your advantage. And I think where we're heading is charging prosecutors with getting inside the defendant's head and turning over, and they'd be happy to turn over everything related to the case.
As long as we provide clear instructions and clear guidance, you're good.
Absolutely, but I don't think that the prosecution should become the investigators for the defense. They can do some of this themselves.
Okay.